But a very warm welcome to you all this evening for this last Northern Province lecture of 2021 on the Canons of the Church of England, reflections on some principles of ecclesiastical law. My name is Sam McGuinness. I am one of the trustees of the Ecclesiastical Law Society, and it gives me particular delight to introduce our two speakers this evening. The Reverend Stephen Coleman is Assistant Director of the Cardiff Centre for Law and Religion and a fellow ELS trustee. And the Reverend Russell Dewhurst is the Chair of the Society's Communications Committee and is just embarking on PhD studies on the principle of subsidiarity in church law and governance. Now, early last year, at the start of the first lockdown, at a time when we all found ourselves stuck at home and coming to grips with this new thing called Zoom, Russell and Stephen were charged with convening reading groups for the Society on the canons of the Church of England. And I myself and many of you here tonight no doubt were involved in those reading groups and found them a most informative and indeed enjoyable experience. And as I recall Stephen telling our group, this was the first time that groups of practitioners and scholars and other interested individuals actually had come together to discuss the canons of the Church of England in any systematic fashion. Now, you might think that as a church which is governed by law and canon, people in the Church of England would have done this before, but the ELS, as it seems increasingly the case, was leading the way. And tonight, Russell and Stephen are going to talk to us about the findings and principles that came out in the discussions of those groups and their experience of studying ecclesiastical law in an online setting. So without further ado, I hand over to Russell and Stephen.
Well, good evening, and it's really good to say hello to friends from all around the country and probably the world for this lecture this evening, and also to see friends from the reading groups that Russell and I convened beginning at during the first lockdown. In fact, I want to begin this lecture by paying tribute to my co-lecturer, Russell Dewhurst. Without him, I certainly wouldn't be giving this lecture this evening. Russell's been associated with the Ecclesiastical Law Society for many years, and as the COVID-19 pandemic began, lockdown took effect, and so many of us, whether we liked it or not, were having to learn how to use Zoom. And Russell saw an opportunity to gather people together, not just from around the country, but from around the world, to read through the canons of the Church of England together, sharing observations and insights. And so the invitation went out to the Ecclesiastical Law Society membership, come and join the Canons reading groups. Now, I think Russell was hoping he might have had just enough interest for one group, around 12 people meeting fortnightly. But interest grew, and so two groups were needed. And then the interest continued to grow. So he called me up and asked me to take on another group and then another group. So we began in May 2020 with 4 groups meeting fortnightly, upwards of 50 people in total, meeting on Zoom to read through and discuss the canons of the Church of England. Amazing, and I can't quite think when in history in the Church of England so many people have been reading through the canons and discussing them at any one time. And it really was, and I hope I speak for those members that are here. You might hear from them later, but I hope I speak for those members who were in the reading groups when I say it was really an edifying, informative, and at times fun way to spend lockdown evenings. Friendships were made, even though many of us had never met in person. And what added to the joy and success of the reading groups was the breadth of the people attending: academics, chancellors, registrars, PCC members, parish clergy, people from the United Kingdom, people from around the world, people from a number of different denominations. So we might ask, why were these groups so popular and why were we so keen to run them? And I think to understand that, we need to look very briefly at what the canons are and their history. When we talk about the canons of the Church of England today, we're talking, of course, about merely one part of the corpus of ecclesiastical law of the Church of England. For as an established church, the ecclesiastical law is made up of all sorts of instruments: Acts of Parliament, measures of General Synod, which of course have the same force as Acts of Parliament, the canons themselves, orders and council, Acts of Synod, quasi-legislation, and then of course there's common law and custom. So what of the canons? Well, within the terms of the Church of England's own legal system, the canons are pieces of delegated or secondary legislation. Today, they are made by General Synod by the power delegated to General Synod by measure, and then they receive royal assent. They are secondary to measures, so if a measure or indeed an Act of Parliament conflicts with a canon, then clearly the primary legislation, the act or the measure, prevails. Yet, in spite of being secondary legislation, the canons are, I think, in many ways some of the most important legislation regulating the life of the Church of England. Firstly, historically, the canons hold a deep significance in the polity of the Church of England. It's just over half a century since the current canons came into force, the product of a revision that began in the first half of the 20th century, which reached a culmination in the 1947 report, and then the current canons promulgated in 1964 and 1969, with subsequent amendments. These canons, which we have today, replace the canons of 1603, 1604. These 1603, 1604 canons themselves were the product of various failed attempts to establish a new independent canonical tradition following the Henrician Reformation of the 16th century. Hence, much of the ancient canon law has been retained in our canons today. It was great that in one of my reading groups we were joined by Gerald Bray. I'm not very sure whether Gerald's on this lecture tonight, but I'm going to quote him now. Gerald Bray notes that, and I quote, "Since Rome replaced the ancient canon law in 1917 and again in 1983, the Church of England is the only major Christian body which still grants some authority to the medieval Corpus Juris Canonici." This became very apparent as we read through the canons in our groups and discussed the historical antecedents in details. Many of our canons today can be traced back not just to the canons of 1604, but to William Linwood's Provençal of the 14th century, such as Canon F1 on the font. And some even earlier than that, Canon B24.5 regarding the minister seeking the goodwill of the minister concerned if he wishes to baptize an infant residing outside the boundaries of his cure, finds its origins in the Clementines of Clement V in 1317. Canon F3 of the Communion Plate finds its origins in Gratian's Decretals of the 12th century. Clearly, the fact that these ancient medieval texts were themselves compilations of canon law show that there are further even more ancient origins to the canons that are in force today. So, firstly, historically, reading through the canons proved hugely important. These rules and norms that regulate our life are part of a great and ancient canonical tradition stretching well back over 1,000 years. What became clear is that the canons themselves are a rich tapestry of ecclesiastical legal history. Reading the text closely, we see changes made to the canons as the Church of England itself developed. The canons are organic texts and are thus witnesses to the changing nature of the Church of England through the centuries. So first significance, this wonderful ancient canonical tradition of which we were delving into and experiencing as we read through them, the narrative of the Church of England expressed in these legal texts. Secondly, the canons are significant because of the shape and content of them means that they regulate so much of our common life today in the Church of England. So and many of you will know the canons, but in brief. The A canon set out the nature of the Church of England. The B canon set out various rules and shared norms for worship, divine worship and administration of the sacraments. It's here in the B canons that the commonality of our shared worship is found, in canons B1 to B5. The regulation of Holy Communion, including the requirement to receive Holy Communion regularly, canon B15. And the regulation of baptism, confirmation, reception into the Church of England, matrimony, ministry to the sick, burial. And also canon B43, which sets out the norms for our relations with other Christian denominations. Then you get into the C canons, dealing with ministers, ordination, how ministers become benefists, institution, collation, induction, and so on. The oaths and declaration of assent, as well as canons relating to the hierarchical officers of the church, archbishops, bishops, archdeacons, rural deans, canons, and so on. It's here in the C canons that we find in canon C25 that priests must reside in their benefices, and canon C27 on the dress of ministers that, and I quote, the apparel of a bishop, priest, or deacon shall be suitable to his office. The E canons regulate the lay officers of the church. The F canons deal with some of the temporalities, the font, the holy table, the plate, church bells, registers, as well as uses of the church building for concerts, exhibitions, plays, and so on. And the G and H canons deal respectively with the church courts and the synods. And I've gone through that because I just want to make the point that it's really clear that the canons touch on so much of the life of the Church of England. They express shared norms and they provide regulation. But as mentioned, they are very much an organic corpus of rules. They are amended when appropriate, either to be consistent with current practice, such as Canon B8 on vesture. That canon was amended by way of private members' motion brought by the neighbouring vicar of the neighbouring parish from where I'm sitting now, Christopher Hobbs at St Thomas's, Oakwood. Or they are amended to be consistent with the measure, such as Canon C21, which now states that both women and men can be consecrated to the office of bishop. But it's not just amending canons. New canons are added to reflect significant issues in the life of the Church of England. The new canon C30 enshrines safeguarding obligations within this canonical tradition, and the new canon DA provides some regulation for religious communities. Now, before I hand over to Russell, who will take you through some of the findings from our groups, I want to say something about the methodology we employed for reading each canon. As we read each canon in the reading groups I chaired, we considered the following questions. Number one, what biblical or theological principles are expressed in this canon? Number two, what are the historical antecedents to the canon? Number three, what was the intent of the legislator in drafting the canon? Number four, is the canon clear, coherent, and comprehensive? Number five, can the canon be enforced, and if so, how? And finally, number six, does the canon remain relevant, and is it observed in practice? So the way we did it, certainly in the groups I chaired, is before each meeting of the group, each member was allocated one of these questions and then came to the group to discuss their findings, and a discussion followed. Employing that format for reading groups was great because it meant that we covered a great range of material for each canon. The theological and historical underpinning of the canons was there, and trying to understand the intent of the legislator, or legislators perhaps, meant that we were led into a discussion of whether the canon was clear and comprehensive, whether it was relevant, and crucially, and we spent a lot of time on this, whether it is or needs to be enforceable. Are these canons meant to be enforceable bits of regulation? Were they intending to be that and no longer are? Are they now merely expressing shared norms? There's a lot more I could say on that, but I'm going to hand over to Russell now, who's going to discuss in more detail some of the findings of our various groups.
Thanks very much, Stephen. And I should say as well, thank you to all the excellent people I got to know through the reading groups who made those Monday evenings in the lockdowns of 2021 such a joy. And as Stephen said, it's great to see many of those names here. For my bit of this lecture, I'm going to talk about three things, and they're inspired by our discussions in the groups, but they're really my reflections as I look back in retrospect, having gone through the canons with two groups in my case. So three things. Firstly, I'm going to suggest how we might categorize the canons. Secondly, I'm going to think about consistency of terminology. Thirdly, whether the canons are, after all, a coherent object of study. So first of all, categories. And before I get to that, I do just want to say a little bit more, add to what Stephen said about enforcement. The 1736 case of Middleton and Crofts held that a canon doesn't of its own force bind the laity unless it's declarative of pre-Reformation canon law or custom. And this precedent has been cited and acted upon sufficiently often for this to be settled law. And a decision about whether to legislate by measure and when by canon is partly guided by that question. Now, as regards clergy, canons can be enforced, at least in theory, by means of the Clergy Discipline Measure 2003 or the Ecclesiastical Jurisdiction Measure 1963. The reason for that is that disciplinary proceedings under the 2003 measure, section 8, may be instituted against any archbishop, bishop, priest, or deacon alleging the following acts or omissions, of which A is doing any act in contravention of the laws ecclesiastical, B failing to do any other act required by the laws ecclesiastical. And the CDM Code of Practice from April 2021, paragraph 6, indicates that canons do fall within the definition of ecclesiastical law. So I say in theory, though, because the published CDM tribunal decisions don't tend to relate to proceedings instituted on those grounds. It may be that such proceedings do not reach a tribunal. And that same code of practice also states that minor complaints should not be the subject matter of formal disciplinary proceedings. So some acts that are contrary to the canons might be enforced by a non-statutory complaints procedure, such as the procedure for resolution of informal complaints that was developed by this Society's Working Party on the Clergy Discipline Measure in conjunction with the Clergy Discipline Commission. But all of that's made a little bit more complicated when you think about executive action, when you think about lay officers. But I just basically wanted to make that point that, generally speaking, the canons are not, by their own force, are not able to bind the laity, before I get on to my categories. So the way I propose, first of my three things, looking at the canons, is to group them into four categories, which are enforceable, facilitative, hortatory, and doctrinal. And I'm going to see if we can get a PowerPoint up on the screen. Give me a second, here we are. Somebody tell me if that hasn't appeared, but hopefully it has. I'm going to switch over to my paper. Now, okay, so this is one of the canons, B38.2. Every priest having a cure of souls shall, except for some reasonable cause, approved by the bishop of the diocese, preach or cause to be preached a sermon in the church or churches of which he is the minister at least once on each Sunday. So based on what I was just saying, in principle, at least this is enforceable under the CDM, I would argue, through proceedings for failure to do any act required by the laws ecclesiastical. So that's the first category, enforceable. But my second category is facilitative. So here's Canon B3.1. It says decisions as to which of the forms of service authorized by Canon B1, other than the services known as occasional offices, are to be used in any church, in a parish, or in a guild church, shall be taken jointly by the minister and the parochial church council, etc., etc. So this canon empowers a minister and PCC to do something. In this case, it's to make a decision. Law, of course, enables us to do things on the primary purposes of law, isn't it? And these facilitative canons, as I want to call them, are a prime example of that. The other way of looking at them, though, is that they are still really a species of enforceable canons, because a minister conducting services contrary to this provision could be subject to disciplinary sanction. So it's a different kind of canon, but still, in a sense, enforceable, if you follow what I'm saying. My third category, hortatory. So maybe things get a little bit more difficult. This is Canon A8. For as much as the Church of Christ has for a long time past been distressed by separations and schisms among Christian men, so that the unity for which our Lord prayed is impaired, and the witness to his gospel is grievously hindered, it is the duty of clergy and people to do their utmost not only to avoid occasions of strife, but also to seek in penitence and brotherly charity to heal such divisions. So the form of this canon suggests it's imposing a duty on clergy and people. Now, I'm not aware that that duty to actively seek to heal divisions is declaratory of pre-Reformation canon law or custom. It seems to be a new duty, and certainly it's very different from the approach of the canons of 1604, which had quite different approach to Christians of other churches and ecclesial communities. So this canon, while it appears to oppose this duty on clergy and people, does not have the legal power to do so. No legal penalty can be imposed on a lay person who does not comply with this duty. Therefore, I suggest it needs to be interpreted as an exhortation, an assertion of a moral duty that it's up to the individual to seek to comply with it or not as a matter of conscience. So the question is Canon A8 law? If one believes there's no law without sanction, then it's not a law as regards lay people. So what is it doing in the canons? I'm going to come back to that question when I've discussed my fourth category, which is doctrinal canons. I think Stephen mentioned this one, Canon DA1, which begins, "The Church of England affirms that since the time of the early church, there have been Christian people who in response to God's call have committed their whole lives to God in the religious life," etc., etc. This canon, I've called it doctrinal. It simply states the belief of the Church of England. Its purpose is doctrinal, it's didactic. Now, this canon might, of course, be called upon in legal proceedings as a source that helps us determine what the doctrine of the Church of England is, but that is true of many sources of doctrine. 39 articles, for example, things that one would not call law or expect to find nestling among the canons. So these last two, I might just stop the share for a moment. These last two categories of canon, hortatory and doctrinal, they're not directly enforceable. They don't carry any sanction. Doctrinal canons don't even take the form of norms which could be enforced directly. Arguably, you could say they do enable me to do something. It means I can authoritatively state the Church of England teaches that without fear of censure. But again, I say that that's true of many doctrines which are not mentioned in the canons. So why then are there these hortatory doctrinal canons included? And so my answer, some of these reflections came out in the discussions, my answer is that from the earliest church history, canons have sometimes taken these forms. Bishop Eric Kemp dated this tradition to the early church. He wrote that much of canon law has always been concerned with the norms of conduct and has indicated standards which the church thought ought to be observed, but was not prepared to enforce by action at law. And in volume 1 of the Oxford History of the Laws of England, Richard Helmholtz sees the same thing in some of the Church of England's canons of 1604. He says, because of the want of express sanctions, these canons must be counted as aspirational in character. That's his word for it. So it's squarely in the canonical tradition that we have these canons, which I'm terming in this lecture hortatory and doctrinal So that raises the question, would there be a gain in clarity if all the canons that couldn't be enforced were removed from the canons and instead included, say, in resolutions of the General Synod? Well, perhaps there would be a certain purity of legal theory, but I think we'd lose something important. For example, religious communities have not always been an uncontroversial part of the life of the Church of England. The presence of that canon DA1 I just had on the screen in the formal, authoritative, abiding context of the canons shows a permanent and prominent commitment to their place among us, able to say, the Church of England affirms, and then what follows in that canon. And on the other hand, a resolution of the General Synod, according to its constitution, only expresses their opinion, that is General Synod's opinion, probably seems more transient. And furthermore, it seems to me that if the canons became something that, for reasons of doctrinal purity, were only strictly going to address those of us who are clergy, because they can only formally bind clergy, I think that would tend to a narrowing and a clericalizing of the church. So I conclude my first point by arguing that there is wisdom in this historic tradition of canons encompassing that which is not enforceable law with sanctions. I'm just keeping an eye on the time, but not going too quickly. So my second point of the three is about consistency of terminology, because as we were reading every fortnight or every week through the canons bit by bit and really looking very closely at the words that we used, the consistency or otherwise of terminology became quite apparent. And different members of the groups were looking from different perspectives, thinking of their own parishes and benefices and deaneries and the particular situations, or those not in parish ministry. So some examples of consistency of terminology. The canons refer in various places to members of the Church of England, a layperson, the people, parishioners of the benefice, all who have been confirmed, members of the Church of England who have been confirmed. Quite a rich variety of terms that need interpreting in each given case on the ground. And very often the reason for this richness of terminology is that in the canons, as Stephen has already pointed out, we're dealing with a kind of historic tapestry, as it's been called. The canons and the phrases in them date from different periods of the Church's history. But that can add a bit of complexity when it comes to the application of the canons and the actual messy situation of parishes on the ground. Got another slide to share. It's going to work. There we are. Here are just from the first few canons, first three chapters of canons, some examples of how clergy are described. And it's quite a range, as you can see, quite a range of vocabulary, quite a lot to be familiar with here. And even if you're very familiar with the vocabulary, there is room, we discovered in our discussions, for ambiguity. Take that canon B3 I read earlier. Decisions about the forms of service that will be used are taken jointly by the minister and the parochial church council. So if in the parish here, West Chiltington, very clear who the minister is, it's the incumbent. But what about other situations? Under Rule 83 of the Church Representation Rules 2020, minister can mean a curate in charge of a conventual district or a team vicar. Can it here in Canon B 3.1? What happens in a vacancy? Can those decisions contemplated by B 3.1 even take place? And will it be easy to understand how to interpret that canon and the other canons as the patterns of ministry develop, which are being envisaged by various diocesan strategies that are around at the moment? What about bishops' mission orders, focal ministers, oversight ministers in minister groups, and so on? So thinking about this richness of terminology, my suggestion is it would be helpful alongside the development of these various strategies forms of ministry, pastoral reorganization, there should be some opinion, some advice provided on how the canons and indeed other legislation will apply in those very diverse situations. I can make a similar point about bishops and ordinaries, various other points of terminology, but keeping an eye on the time, I'll stop this share and I will skip ahead to my third point, which is coherence. Coherence of the canons. Now, if this weren't the Ecclesiastical Law Society, and I were to suggest a reading group instead on the law of insolvency, and if I were to say we're going to read all the statutory instruments, but no Act of Parliament, I think you'd probably think that I'd taken leave of my senses. So does it, by analogy, make sense to read and discuss the canons of the Church of England over 9 months, but no measures? Are the canons a coherent body to study? Well, first of all, I should say that we weren't doctrinaire in what we were doing. We did, at least in our groups, refer to measures, cases, customs, precedents, forms, guidance, canons of 1604, and more when they were interesting and relevant. But the topics covered by the canons did shape the discussions. And following the canons meant that we left out important matters of church law. Stephen's already alluded to this. Parsonages, for example, the details of clergy discipline procedures, we didn't touch on them. But what we found was that the topics covered were ones that were identifiable and relevant to all those involved: clergy, lawyers, academics, historians, PCC members, ecumenical colleagues. The church's constitution, liturgy, ministry, religious communities, lay officers, church buildings, courts, and government. That's what the canons cover. Those topics relate, by and large, to people's direct experience of the church. Only rarely do the canons get bogged down in page after page of procedural rules. Most of the canons, we found, provoked really interesting discussion, comparison, evaluation. And they're the body of law that clergy, at least, are most likely to have on their shelves or in their electronic bookmarks, probably alongside the church representation rules. So the idea of treating the canons as a coherent body within ecclesiastical law, worthy of attention and study in its own right, I would say, has been vindicated by our experiment last year. Okay, to finish off, if I hand back to Stephen, I make one final point that might help answer the question, what are canons? And I would argue that the power to legislate by canon is inherent in the church. The convocations, Canterbury and York, had an ancient power to legislate by canon, which did not originally derive from parliamentary statute. In the 16th century, as we all know, there was a renewed and reformed understanding of the royal supremacy. And that meant that this power to legislate by canon was subject to royal assent and other constraints under the Submission of the Clergy Act 1533. And then, as Stephen, I think, mentioned, in the Synodical Government Measure 1969, that power was transferred to the General Synod, with both convocations having previously resolved that they would welcome that change. And I rehearse all those points to say, really, that the power to legislate by canon is one that's regulated and recognised by the state, but was not originally created by the state. Canons are, in a very particular sense, the church's own law. The church needs the power to legislate by measure because so much of our law is tangled up with acts of parliament. But as regards spiritual matters, such as liturgy and ministry, the canons, with their unique categories and character, remain, I think, the most appropriate way of ordering the life of the church. I'm going to hand back to Stephen now to conclude.
Thanks ever so much, Russell. and that's really interesting. And I think what's come out of that for me is I think each group were coming up with different things. There were different thoughts, and there was such a, I keep saying this word tapestry, but there was such a tapestry of different understandings that were coming through. So it was a very rich experience. Just before we open this up to questions, I think I'm just going to say a few words in conclusion. I know I'm preaching to the converted, but I'm sure it's long been the hope of those of us engaged in ecclesiastical law that wider coverage could be given both to the study of ecclesiastical law and, for us, the study of the canons. To me, it's interesting to note that these reading groups that took place during lockdown and really retained their popularity coincided with the importance of ecclesiastical law becoming much more prominent in the Church of England and other denominations as the Church of England and churches responded to COVID-19. So looking ahead, we very much hope that we can harness greater interest in the study of the canons, not just from an academic perspective, but from the perspective of all engaged in the life and mission of the Church of England. With that in mind, Russell and I are looking to publish a short, accessible introductory commentary on the canons based on our findings in these reading groups. The idea is that they will serve as a reference point for ordinands, clergy, ecclesiastical lawyers, PCC members, and all involved in the life of the church and church governance. We hope that it might facilitate diocesan study days or deanery reading groups, and also be of interest to Anglicans overseas, whose canonical systems are cousins to the Church of England's. So there's much more work ahead, and I just want to say thank you again to all those who are gathered and absent friends as well. And they are friends now, even though I haven't met many of them in person, who played such a great role in these reading groups that took place. I think now I'm going to hand back to Anne-Marie, or to Sam, who's going to open the Zoom floor to questions.
Thank you, Stephen. Thank you, Russell, for a fascinating discussion, distilling some of the wisdom and principles that came out of so many months of work last year. As Anne-Marie said at the start, if you could please use the raised hands function for anyone who wants to ask questions, and I can keep an eye on that, and I can then work out with Anne-Marie who's going to speak next and ask their question. But I think I'm going to kick off. So Russell, you came to the conclusion that the canons do remain essential and indeed central to the legal structures of the Church of England. I just wonder if you and Stephen, in your deliberations, have you thought about if we started again tomorrow, if we said, right, we're going to start with a completely fresh set of canons for the Church of England, would you still have this mishmash of 3 or 4 categories of canon, or would it simply be restricted to sort of fundamental norms, doctrinal and hortatory norms perhaps, about what the Church of England is, and then allow a body of measures to build around that? Or do you think it could be, would it be more useful to have this sort of mixture of enforceable enactments and other parts?
That's a great question, Sam. I think that this mishmash, as you call it, great word, kind of just comes out in the wash with canons, because when in the Canon Law Revision Committee report from 1948, I think Cyril Garbutt's introduction, he talks about the purity of law, and it must have sanctions, and that the revised canon law should just be these proper laws and not the teaching and so on from the older canons. But even there, in that draft that accompanies that report, there are the first 8 or 9 are exactly of that kind. He says they're not going to have all the way through. I think you can't avoid it, just because of the nature of canons. Since the very beginning, they've carried this teaching function, because by and large, despite these theoretical points about clergy discipline measure, by and large, the effect they have is through teaching and through people choosing to obey them. And yes, you do need to be able to enforce them where people's rights are at stake. If the clergy were doing nothing, and the parishioners were not getting what they needed, it would need to be enforceable. But by and large, 99% of cases, they're performing a teaching function. So I think that the mishmash, is fairly inherent, and it kind of works.
Yeah, I mean, I think I would just add to that it's always interesting, isn't it, when we say, well, if we started again. And the complexity, I think, for the Church of England in starting again is, as much as I was saying at the beginning, the historical development of the canons are such that it's amazing they're as systemized as they are. And of course, if we look at the period from the reign of Henry VIII, Joe Bray's very good on this. There was this great initial excitement that we're going to reform the canons of the canons, and we're going to have a new system of canon law. And people quickly lost interest, and it took to 1603, 1604 for that to become a reality. And again, the next revision began with conversations in the 1920s and 1930s, and it took to 64 and 69 for this to become a reality. So, and I think part of the reason for this is because there's so much out there in terms of, and so much that could be lost if you did try and start again. We had some Roman Catholics in the groups that I was doing, and the comparisons with the 1983 Roman Catholic Code of Canon Law are particularly interesting here, because obviously that is a systematic code of canon law. That is the canon law for the Roman Catholic Church. I'm no expert on it at all, but the nature of us being an established church means that we have law all over the place, and that's that makes life much more complex as well. So it's a great question, Sam, but I couldn't even begin to think how we could start again, really, I guess.
Thanks both. I'm glad we're all common lawyers at heart and we're keeping the mishmash. I think our next question is coming from Neil Patterson. Neil.
Thank you, Sam. I wonder if Russell and Steel, a bit of introduction to this on the question of the position of the laity, both in terms of the making of the canons and their enforcement. So, as many people here will know, the convocations, the revival of the convocations was a long, slow process from the 19th century, but for a long time they were hampered because they were not being given permission to make canons. And as I have, my research is, there's an article by Peter Bolton in our own journal, is that when it came to the 1940s and the report that Russell's referred to came out, the government, in the person of Thomas Barnes, the then Solicitor General, effectively said, you can make canons, but only if the House of Laity are involved. And if one follows the process of canonical revision, the convocations contained the principle that they were their canons, following the ancient point that Russell made. But in fact, the House of Laity effectively worked as a revising body. And it's interesting, some of the commentators from that sort of period say cheerfully, well, now the laity have been involved in making the canons, they will clearly be binding on the laity. And yet that hasn't worked out. We still, Middleton Croft still holds. So I just wonder about that. That says, what is the church? The convocations anciently were wholly clerical, clergy and bishops, and made canons, which before the Reformation could be enforced upon the laity. Now the laity aren't built into the legislative structure, and yet the standing of the canons is still varied. I just think it's so interesting paradoxes there about who makes law, who is bound by law, and so on, or make by canon. Well, as well.
I mean, I might just begin on this. I'm not going to give you an easy answer, but Russell may have something more developed to say. I think when we started in one of our reading groups, we began straight away. It may have been the one you were in, Neil. In fact, I think we began talking about Middleton and Croft, and we spent a lot of time on it. And I think Rupert Bursow said, if we're not careful, we're going to discuss this case at every single reading group almost. So and I think it is such a key question. I think it is such a key question. What is the effect of Lord Hardwicke's judgment of Middleton and Croft? Is it still relevant today? Of course, it's the precedent still. The precedent, I guess, still holds. But I think the question is open and twofold, really. What the effect of amending canons because they're going through logically, to me, they're going through a synodical process that involves the laity, as I understand it. I'm not a member of General Synod, but as I understand it. So therefore, why wouldn't they be? Binding upon the laity? It's interesting you say that they're not. But also, we talk about the canons, but we have so, as I said, we have in the beginning of this lecture, we have so many other bits of ecclesiastical law. So it becomes a real mishmash, because even if you say the canons aren't binding on the laity, well, but some of the canons, the canons are made by measure, which are made under the authority conferred by measure. So obviously the laity are involved there, and also there's a question of where canons are merely giving some sort of canonical authority, if you like, to primary legislation. So that's a very confused answer. But I really think, and I've said that Norman Doe and I have discussed this. I think more work needs to be done on Middleton and Croft to try and get some sort of opinion on its authority under our current system. Russell, I don't know whether you've anything to add.
Yeah, I think it's a great question. Thank you, Neil. I've got 4 points to make in response. Firstly, it's really interesting, the case, Stephen's already said, the authorities of the day in 1736 generally were contrary to what was held in that case. When you read the judgment, it's not at all obvious. Well, I would argue that principle that the canons don't bind the laity is not part of the ratio decidendi, but it's been taken as such for so long. As I said earlier, you have to take it as settled law. So the question as to whether the laity are making, because they're now drafting the canons, but the question is, to my mind, who are the laity? Because the franchise for General Synod are baptized people who are over 16 and willing to say that they are members of the Church of England and not ordained in terms of the House of Laity. So is that sufficient representation to bind everybody in the country? Or is it, the members of a club or the members of a church? And so would you say that binding the laity would just bind those who are members of the Church of England? In which case, who is that? So I think there's that huge question, which again came again and again. So the lay franchise is members of the Deanery Synod, Neil's put in the chat. That's true, but they're elected. The Deanery Synod are elected. I'm thinking of the electoral roll members who elect the Deanery Synod members. So that's what I mean by the franchise. Obviously, when it comes to those who are directly electing, it's even narrower, as you suggest, because they've also got to be communicants. So there's that question of who is being represented, and that opens a lot of can of worms then about what does member of the Church of England mean. And then my final point is, it's also a very theoretical question, because there's no mechanism for the canons to bind the laity for the most part. And if there were a mechanism to be brought in, it would have to be brought in, I would suggest, by a measure, in which case, if there was a will and Parliament was going to agree, then the canons could bind the laity under this new system. I mean, I think it's vanishingly unlikely to happen, except, as I say, conceivably with membership drawn very narrowly in certain circumstances. But I don't think it's likely to happen.
Thank you both. Thank you, Neil, for your question. We have a raised hand from Augur Pierce. So, Dr. Pierce, your question.
Hello, thank you. I'll just turn my video on as well, though it may not be very good. Yes, I confess to being a wholehearted believer in the authority of Middleton and Crofts. But whether one is or not, what Middleton and Crofts seems to say is that a canon is one of two things. It's either a restatement of a general law, which binds everybody, but it draws people's attention to it, or it is self-regulation by the clergy for the clergy. Well, the first category is the restatement of the general law, and there's a good deal of the canons which do restate what you can find elsewhere, like in a measure, what happens to the force of those canons which restate the general law as it stands when the canon is promulged, when the general law changes? Does the canon which restated that law have any additional force, or does it just become totally spent and defunct?
I think that's a really interesting question, Olga, and I just want to say as well and note how good it was to have you in one of our groups, bringing the ecumenical perspective and your unique historical perspective to so many of these questions. I mean, I find it a little unsatisfactory when the law is repeated in multiple places, precisely because, as you say, it can easily get out of sync. So the law is on, marriage hasn't been updated. I mean, I suppose technically, in many cases, one has to read it that the clergy are still bound. So if there's been a lessening of a restriction by measure, but the canon remains the same. And this was true, for example, in the 1930s. I mean, hundreds of examples, but when marriage law was widened in certain circumstances, and the convocations stated, well, we are clear that the clergy are still bound by canon here. So in those circumstances, I think that's the answer. But the other aspect to this repeating of the law is, I think it can be misleading, because somebody wanting to find out the law about marriage or funerals might read the 2 or 3 canons and think, now I know everything. Remember everything there is to know about the law of marriage because I've read the canons. And it's really important they follow up those references to measures and acts. Do you want to add anything, Stephen, there?
No, nothing on that. Thank you, Olga, for the question.
Thank you. We've got a bit more time. Still looking for questions from the floor. I've got another one, actually. I'm heads up now. This touches on the whole notion of the historical continuity of the English Church and the organic development of our canon law. I was just wondering if both of you or either of you have had a chance to think about in what particular areas and to what extent the medieval corpus of canon law does still play a role in helping us to interpret our canons today, and indeed other legal principles within the Church of England.
Over to you, Stephen.
Right. Yes, I mean, I was just about to say over to Russell. So I was just like, so you're really the place of the medieval canon law in terms of enforceability today. Did you say, Sam, or interpretation?
Well, just in how it helps interpret the current canons.
I mean, I think looking at, as I said earlier in the lecture, I think looking at the historical antecedents, particularly given the very ancient parts of some of our canon law, to me it's a little bit less about interpretation, but more about us, being part of this greater narrative of a canonical tradition that stretches back to Linwood, but to Gratian, and in a sense back to that. And of course, some of the things we can find their original origin in not just the early ecumenical councils, but in the of course in biblical principles and patristic thought as well. So it's for me, it's back to this sort of tapestry idea that we look at certain things, and some things that today we might think are a bit strange. A minister, I mentioned this, I know, but a minister has to seek the goodwill of if a minister is going to baptize an infant residing outside his or her cure, the minister has to seek the goodwill of of the minister where the parents are residing. Now, today, in many ways, that might seem to be a block, perhaps, to the mission of the church. But in some ways, its importance to me rests on the fact that that is such an ancient principle in canon law. So sort of from an interpretive point of view, I think, observing these things in the breach or saying, oh, well, they don't really apply anymore, that's quite a significant thing we're saying. When we've had almost a millennium of that canonical principle applying in England. So to me that's what's particularly significant. So it's a very good question. I don't like to put well, no, I was going to I'm very conscious that in some of the groups I was in, Paul Barber, I don't think he's here, but also Ian Blaney, who is very keen on the historical side of the canons. Ian, I don't want to put you on the spot, but do you fancy helping me out with that question a little bit?
Sorry, I've not prepped my mind really to apply myself to that. I think it's actually very difficult to work out what is left over from the ancient canons, the medieval canons, what's not been either explicitly overrided with the making of new canons, or which has been impliedly overridden with the changes in statute law, which would make some medieval canons repugnant in the words of the Tudor legislation. And I think it would be helpful, I don't know whether it's been done, if someone, I know Rupert Bursell and others have looked at this, I don't know whether they've done it in a very taxonomic way, to actually sift through and work out what has survived and whether what has survived should be revoked or sort of put onto the canonical statute books, as it were, because I think that would be very helpful for us to have continuity with our ancestors and to look towards the future, to have that continuity of canonical tradition actually set down in writing, rather than have it as a very historical exercise. It's complicated even more when you have to think about custom as well, because custom is something that binds the church. Custom may be something that was never written down, but still has some validity. So really, this is a job for historians, it's a job for lawyers, it's a job for churchmen. And I very much hope that someone would, if it hasn't already been done, will put their mind to it.
Ian, thanks ever so much, and sorry for putting you on the spot there, but that's just like old days, that, isn't it? When I was in the reading group, so doing the reading group. Thanks ever so much. I mean, I would do a little plug here. Gerald Bray, who's in our reading groups, has just done another edition of a book, The Development of the Canons. This is the canons from 1969 to 2020 or 2021, I suppose. But actually, the way it's done is that it's all footnoted. Back to the original, as far as we can get back to the original authority of the law. So whether that's 1604, Linwood, Gratian, Clementines, or so on. So that's a really good resource. I'm sure he'll be pleased that I'm plugging his new book. Russell, I don't know whether you've got anything to add.
My only thought is when there was the canon law revision in the middle of the 20th century, some people wanted, for the reasons Ian has pointed out, there to be greater clarity, and that all the pre-Reformation survivals should either be abolished or should be written down. But it wasn't done, and so in theory there are these holdovers, but nobody seems to. I mean, can anybody on this Zoom meeting put your hand up and give an example of a pre-Reformation survival canon that is still active in the Church of England today? It'd be great if someone can. I suggest it maybe no one will put their hand up, and I wonder if nobody here does, whether there'll be many places where anybody does know that without the detailed research that Ian's already commended.
I mean, I think we can, Russell, I think we can find bits. Of course, we can find bits of the pre-Reformation canon law, as I said, throughout our canons. But what you're saying is a canon in its completeness. Is that what you mean?
I mean something that isn't in our canons, but that somewhat that is still a pre-Reformation canon that hasn't been abrogated because of statute, a more recent canon, custom, and so on, and so survives. Yeah.
Yeah. Okay.
I see Augur may have raised his hand on that point. Or maybe not. Oh.
I did, but actually, when when Stephen gave his last reply, I thought that possibly what I was going to offer was simply an example of a legal principle which you could not track down to any one specific canon. I mean, the idea that a patron's presentee needs institution by a bishop, you will not find that stated in the Jacobean canons, and clearly it was around throughout the Middle Ages, or at least certainly from the sort of 11th century. But whether you'll find in Lindwood or somewhere else an actual statement of that, I don't know. Clearly, it has been recognised ever since as part of the procedure for appointing parish clergy.
Yes, I mean a lot, as some of you know, a lot of my research or my doctoral research on the legal history of patronage law. So thanks for that example, Olga. Is what the canonists in the 17th and 18th century were saying about patronage, and they make statements that aren't in the 1604 canons, but they speak of them as authoritative of law. And to me, there's perhaps a separate piece of work on the authority that they carry, because they all talk about their predecessors as if, well, this is the case. You know, Richard Byrne will say this is the case because Edmund Gibson said it was, and Edmund Gibson will say, well, that's the case because John Godolphin said it was, and so on. So it's I think there's the thoughts and writings of those canonists help us along the way a little, but the authority of their writing is also a point of discussion, I think.
There is the test, of course, in I think it's in Bishop of Exeter and Marshall, that if you're going to argue a piece of pre-Reformation canon law, you have to show that it's been pleaded and proved since the Reformation. Now, that wouldn't really make sense if you could still go on doing that now. You could plead for the first time something that had never been invoked since the Reformation. So I think it means pleaded between Henry VIII and the House of Lords decision in Bishop of Exeter and Marshall.
Thank you.
Thank you all for those insights. We have another question now from the TST Benefice.
Yes, thank you very much. Can you hear me?
Yes.
Thank you very much for taking that. My question is about the relationship between canon law and the 39 articles. You mentioned that briefly in the lectures, but the term that I hear most is that it is set aside. It doesn't matter anymore. Is it recognized by canon law? What is the relationship? Thank you.
Thanks very much for the question. The 39 articles, they certainly are mentioned in the canons in part A. So there's the very second canon, A2, is actually called a canon of the 39 articles of religion, that sort of tells us that they exist, and I think it says they're not they are agreeable to the word of God. And then canon A5 of the doctrine of the Church of England, which is a great canon, 2 sentences summarize the sources of doctrine, which I certainly find very helpful. And that says that I'm going to have to read it, hang on. The doctrine of the Church of England is grounded in the Holy Scriptures and in such teachings of the ancient fathers and councils of the Church as are agreeable to the said Scriptures. In particular, such doctrine is to be found in the 39 Articles of Religion, the Book of Common Prayer, and the Ordinal. So a lot of people have interpreted that, both since this canon and in fact before, in different presentations, of saying that this is a little bit different to how it used to be, subscribing the articles, and the way that the 1604 canons put a very narrow terms of interpretation on 39 articles. This is seen to be a little bit looser. The doctrine of the Church of England is to be found in the 39 Articles of Religion, but that perhaps means, arguably, that one doesn't have to say that absolutely everything in them is doctrine, or that, you know, so for example, some clergy might believe that the death penalty is illegitimate, and I think they can hold that belief without probably being too much danger of being held to be, you know, illegitimately contrary to the 39 articles. So that would be my answer.
Yes, I think, thanks, Russell. If I could just come in, I mean, it's interesting that Russell thought straight away about the A canons. I immediately thought about the Declaration of Assent, which of course is enshrined in canon law and the canon C15. It's interesting that the A2 says that the 39 articles may be assented unto with a good conscience by all members of the Church of England. Could suggest there was some question mark over whether they need to be subscribed to. However, of course, that the preface to the Declaration of Assent, so given canonical authority under C15, says that it mentions the 39 articles along with the Book of Common Prayer and the ordering of bishops, priests, and deacons as bearing witness to the Christian truth and its historic formularies, and then the Declaration of Assent effectively, you know, the person making that declaration, as they're ordained or as they're instituted to a benefice or whatever, it basically says they're assenting to them. But I would agree with Russell, even with that, it does seem to be watered down, perhaps, compared to the 1604 canons, which I think talk about subscription to them. Does that go anywhere to answering your question?
Thank you very much. Yes, it does. It's always a difficult thing, isn't it? Because you're not always referring to canon law, but this is something you can see in the prayer book, and you tend to sort of skim through it quite a bit in comparison to, unless you're in dispute of something, you check the canon law. But most of the time you look at the 39 articles. Thank you.
Thank you. Quite a helpful comment there from Olga Pierce in the chat. Thank you, Olga.
Yes, thank you. A very fruitful discussion, I think, on remembering all the different sources of authority that we have within the Church of England, and again how the work of these reading groups has begun just to scratch the surface and how they may all fit together. But as I say, I think it just remains for me to thank Russell and Stephen for their talk this evening.